Okay, let's start with polity test number 6. This is the first question. There is a statement given. What is it? Goes like this: it shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to particularly linguistic minority groups. This was a statement directly taken from the constitution itself. So there are three statements given. First statement is part of it is it part of fundamental rights under part 3 or not? We have gone through fundamental rights, right? Does it come under? This is a exact statement taken from the constitution. You have to identify where it is located in the constitution. So this talks about instruction in the mother tongue to the particularly linguistic minorities. So protection of minority rights, it is given in the constitution under article 2930. Protection of minority rights, cultural and educational rights of minorities were given, but this particular statement is not in relation to article 29 or 30. This particular statement is related to linguistic minorities, protection of their language, particularly their respective mother tongues under article 350A. There is under article 350A, the direct statement is there in the constitution, so which we have discussed also in the class. We have discussed this. So this is not related to, this is not part of fundamental rights, and again this provision made under act of parliament, no, this is again in the constitution. So this is again the second point is also not correct. And the third thing, this is justiciable in the courts if not implemented by the government of India. No, this doesn't come under justiciable part. Okay, yeah. So the answer is none of the above. So under article 350B, there is a special officer for linguistic minorities. It is there. You recollected it, right? We have discussed in the class. Under article 350B, there is a special officer. There shall be an officer for the special officer for the protection of minority rights, particularly their language, linguistic minorities. So all of these statements are wrong. The answer is none of the above. And the second question, consider the following statements regarding the pardoning powers of president. This pardoning power of president comes under which powers? It falls under judicial powers. President has various powers. Under that one head is judicial powers. Under this pardoning power comes. This pardoning power of the president, point number 1, the power of pardon shall be exercised by the president on the advice of council of ministers. This is statement 1. Is it correct or not? The power of pardon shall be exercised by the president on the advice of the council of ministers, because the council of ministers is there to aid and advise him on every matter. So this is correct. The second point is the president can exercise these powers in all cases where the punishment or sentence is for an offence against any law relating to a matter which the executive power of the union extends. Is it correct or not? This is pardoning power. The pardoning power extends. This is exclusively in relation to pardoning powers only. Not so. There are two kinds, particularly in cases of death sentence and court martial, where governor doesn't have power in this regard. He doesn't have a pardoning powers in both these aspects. So the president has the pardoning power till the executive power till the extent of president's pardoning power, it is extended to till the executive power of the union extends. You got it, right? సో ప్రెసిడెంట్ యొక్క ఎగ్జిక్యూటివ్ పవర్స్ త్రూ అవుట్ ద కంట్రీ ఎక్స్టెండ్ అవుతాయి కదా. సో ఎంతవరకు వాటి ఎక్స్టెంట్ ఉంటుందో ఈ ఎక్స్టెంట్ ఆఫ్ ద pardoning power also it will also extend to the same extent. Then the third point, the original constitution has provided a small window for judicial review. Is there a concept of judicial review for president's pardon? No. So the answer is 1 and 2. The answer is B. So there is no judicial review, because that is again an extraordinary power which was given to the president to be used very cautiously only under certain circumstances, because even the judiciary may also go wrong, right? So under those circumstances it must be, the pardoning power must be exercised very cautiously by the president. The next question is, with reference to the procedure for the amendment of the constitution as laid down in article 368, because see there are two ways the constitution can be amended. One thing is under article 368, and there is ordinary constitutional amendment. Constitution can be amended in 2 ways, ordinary constitutional amendment and then under article 368. So this is like ordinary bill only, it can be passed with simple majority, but under article 368 it requires special majority. So having said this, under article 368 consider the following statements. Point number 1, an amendment of the constitution can be initiated only in either house of the parliament. Is it correct or not? Why is it correct? Because it cannot be initiated in any of the state legislatures or anywhere else. An amendment can only in either house of the parliament, whether it is Lok Sabha or Rajya Sabha. It can be initiated only in these 2 houses, not in any other house, which means not in any state legislature or legislative assembly or Vidhan Sabha or Vidhan Parishad, whatever, you cannot introduce there. So this is correct. And the second point is, the bill can be introduced only by a minister and not by a private member. Is it correct or not? Is it correct or not? Any person can, whether it can be a minister or a private member, anybody can introduce a constitutional amendment bill. There is no bar. That only a minister should introduce this. No, nothing. It can be introduced in either house and it can be introduced by any member of both the houses, whether elected member or nominated member, it could be anybody. And the point number 3 is, prior permission of the president is not required for the introduction of the bill. Is it correct? Yes, it is correct. So the ratification by the state legislatures, is not required. Is it correct or not? So the ratification by the state legislature is not required, which means it is the state legislature, when they come into picture, when this particular condition of ratification by 50% of the states, when will this come into picture? If the issue is federal, if the matter is a federal matter, then the ratification by 50% of the states along with special majority. Special majority with 50%, ratification by 50% of the states. Certain things, federal matters, require the consent of the states also. So the ratification by the state legislature is not required, which means it is correct or not. Certain cases it is required, right? So this is not correct. So the answer is, what is this? Fourth one is wrong. Okay, fourth one is wrong, and second one, the bill can be introduced. Okay. This is also wrong. So 2 and 4. Answer is 2 and 4. Next question is, consider the following statements. Parliament may by law regulate any matter relating to or connected with election of the president or vice president. Okay, is it correct or not? Who will regulate any matter related to the president or vice president or anything for that matter in the country? Who will decide? It is the parliament, because it is the people's house. So it is the people's representative who constitute the parliament. That's why they have the sole authority, as long as those amendments or changes are within the purview of the constitution, basic structure. As long as they fall under the basic structure doctrine, parliament can amend anything. So any parliament through law, it can regulate any matter relating not just to the elections or any other matter. So this is correct. And the second thing is, all doubts and disputes arising out of the election of a president or vice president shall be inquired into and decided by the Election Commission of India, whose decision shall be final. Is it correct or not? No. Why? Who will decide? Yeah, it is the Supreme Court. It is the Supreme Court which decides all matters related to the election dispute of particularly president and vice president, but through an election petition. Through an election petition, Supreme Court only entertains any election related dispute or any matter related to the election of the president or vice president through an election petition. An election petition in the proper form must be filed in the Supreme Court, then only it will entertain. Okay. So this is wrong. So the answer is only one. So next question, consider the following statements regarding the legislative powers of the president. These are the what are the legislative powers of the president? So president has so many powers, right? Executive powers, legislative powers, judicial powers, financial powers, etc. So under this, there are certain legislative powers are bestowed upon the president. So let's see the first point. He can send messages to the houses of parliament with respect to a bill pending in the parliament. Bill means a legislation. So this is related to the legislative powers. If any bill is pending which is in the national interest, if the president wants to expedite the issue, he can ask the house, he can send message the house to to expedite the issue. So to make the bill pass, or they may reject, but they cannot postpone it or kept it pending, right? So that's why he can issue messages, he can send messages. That is correct. He decides on questions as to the disqualification of members of parliament in consultation with the prime minister. Is it correct or not? There are certain disqualifications which we have seen which I have discussed. What are those? One thing is constitutional disqualifications. Certain disqualifications are constitutional. They have their roots in the constitution itself. The other are, what are the RPA disqualifications? These are legislative disqualifications are based on RPA. The RPA, Representation of People Act, has provided certain things which disqualifies based on certain grounds, it disqualifies certain members. And the third is anti-defection. If any members defect from one party to other, that can be curtailed, or that persons can be disqualified based on the anti-defection on the 10th schedule. So under this, the anti-defection based disqualification is done by whom or decided by whom? Is the presiding officer. Yeah, presiding officer of the house. And other disqualifications are done by whom? President, on the recommendation of Election Commission, not Prime Minister or Council of India. Based on in consultation with Election Commission. So ikkada em vastadi, instead of Prime Minister, in consultation with Election Commission. So the second one is wrong. So the third point, in case of Puducherry, the president can legislate by making regulations, but only when the assembly is suspended or dissolved. Is it correct or not? Can president make legislation for union territories or not? Union territories? Yes, right. Particularly where there is a legislature, there is a legislature in only 2 of the union territories. One thing is Delhi, another is Puducherry. So president can legislate even in these instances also, these cases also, but when that particular assembly, legislative assembly, when the legislative assembly is either suspended or dissolved. Under those 2 circumstances, normally who will make that particular legislative assembly, respective legislative assemblies will make the legislation usually. But when they are either suspended or dissolved, under those circumstances the president will directly legislate. The president will make legislation that will be implemented by the respective union territories. So this is correct. So option is 1 and 3. No, and that is see whether when the president will issue ordinances, when the houses are not in session, right? When both houses are not in session, in the parliament also, in the central government also, when the president will issue the ఎప్పుడు ఇష్యూ చేస్తారు? No, that is anti-democratic, right? That is against democracy. The assembly was legitimately elected by the people, right? So it cannot be unnecessarily you cannot subvert democracy. Democracy ni manam pakkadari pattinchukoodu, unnecessary eppudu when it is necessary, when either the democratically elected assembly is either suspended or dissolved, then only the president can intervene. That is the democratic way. Otherwise it will be anti-democratic. No, it doesn't permit. A constitution is not possible. Only under extreme circumstances, even when the president rule will be imposed. President rule eppudu impose chestam? When under 256 gaani 265 gaani, when the constitutional machinery in that particular state, if the state is not run according to the constitutional machinery is failed to, or if the states comply with the guidance or directions given by the center, under those 2 conditions 360 to 256 gaani 265 దాని కింద ప్రెసిడెంట్ రూల్ ఇంపోజ్ చేస్తా. సారీ 356 and 365. సో నార్మల్ సర్కమ్స్టాన్సెస్లో చేయరు కదా. మన కాన్స్టిట్యూషనరీ మెషిన్ ఫెయిల్ అయినా, లేదంటే సెంటర్ when the states fail to comply with the directions given by the center, under those 2 circumstances the president rule will be imposed. So here again ikkada kodanu same, when the either when the assembly is suspended or dissolved, then only the president intervenes and make legislation. Otherwise the president is an executive authority most of the time. Of course he has legislative powers, but he doesn't intervene in the normal course. For filing public interest litigation bill, the Supreme Court invokes which of the following jurisdiction? Supreme Court invokes which of the following jurisdiction? There are certain. What is appellate jurisdiction? It is related to the appeal. It is related when a lower court makes a judgment or a decision. When somebody comes up to the Supreme Court through an appeal, then it will takes up that particular case and delivers the judgment based on its merits. That is called appellate jurisdiction. There should be an appeal from the lower court's judgment to the Supreme Court. That is called appellate jurisdiction. And advisory jurisdiction, what is it? Advisory jurisdiction? Yeah, president as the executive head of the state, he can ask for the advice of the Supreme Court under certain conditions, like we have discussed in the class regarding the pre-constitutional agreements or acts. In relation to that, if he gets any doubts regarding what for a fact or for an interpretation of law, he can seek the advice from the Supreme Court. So Supreme Court must tender its advice in this particular case. So that is advisory jurisdiction. So here the president or the executive seeks the advice of the judiciary. We have three organs of the state: legislature, executive and judiciary. If the executive means he is the executive head, right, president, if he seeks the advice of the judiciary, if the one organ seeks the advice of the other organ, then they in this particular case they must tender their advice, and he may not follow, or he may follow or may not follow, take that decision, but that comes under this advisory jurisdiction. Whereas writ jurisdiction means we have seen several writs under Article 32 of the Constitution, and also which gives writ jurisdiction to the Supreme Court, whereas Article 226 gives the writ jurisdiction to the High Courts. So under Article 32 in Supreme Court, one can approach to the Supreme Court under jurisdiction, writ jurisdiction. This pill concept comes under, this was originated in early 1980s, means somewhere in 1982, something like that. There is like famous judges, you know, Bhagavati, Justice P.N. Bhagavati, then Menon, Justice Menon. All these eminent judges, they came up, they have encouraged as part of judicial activism. We have discussed what is judicial activism and all. Judicial review we have discussed, judicial activism also we have discussed in the class. Under this particular pill concept comes under the it is a part of judicial activism. So judiciary, when there are three organs, if the other two organs not up to the mark or not playing their role properly, then the judiciary intervenes and it activates. If they are passive, it makes them active. So the judiciary makes them active. So that's why it called judiciary is playing active role here. That's why it's called judicial activism. Under judicial activism, it has a long history even in USA, which we have discussed in the class. But here in India, it was conceptualized through the concept of pill, consolidated through concept of pill. So now we can, in order to exercise the judicial review or judicial activism concepts, we can use this concept of pill under the writ jurisdiction of the Supreme Court. The writ jurisdiction under Article 32 only applies to the violation of the fundamental rights. If the fundamental rights of the citizen violated, of any individual got violated, then under Article 32 one can approach the Supreme Court, whereas the jurisdiction under 226, the jurisdiction of High Courts under 226 is wider because it includes both fundamental rights as well as legal rights, other legal rights. Got it, right? It is wider than the, not in scope, not in extent. Extent means the Supreme Court jurisdiction extends over the country, entire country, but the High Court jurisdiction extends only to the state concerned. But when it comes to it is not the territory, the territorial extent of the Supreme Court is definitely more, whereas though the territorial extent is lesser, the scope is wider. The scope is wider because it also covers not only fundamental rights, but if your legal rights, some of your legal rights violated, then also you can approach to the High Courts under writ jurisdiction. Okay, next question. Consider the following statements regarding the President's rule that is imposed under Article 356 of the Constitution. President, just we have seen that President rule can be imposed in any particular state under Article 356. According to this, certain statements were given. The first one is, it cannot be imposed without the written recommendation of the governor of the state concerned. Is it correct or not? Is it correct or not? So it was given without written. So you have to read the statement carefully. So it can be imposed without the written. It cannot be imposed. Is it correct or not? Whether it can be imposed or not. Is governor's recommendation or written communication in this regard is mandatory or not? So it can be oral. So does oral recommendation or oral communication mean anything nowadays? So మనకి 1975 ఎమర్జెన్సీ తర్వాత మనం కాన్స్టిట్యూషన్ మళ్ళీ అమెండ్మెంట్స్ వచ్చి 44th కాన్స్టిట్యూషన్ అమెండ్మెంట్లో వీ హ్యావ్ నలిఫైడ్ ఆల్ దోస్ బికాస్ వితౌట్ రిటర్న్ కమ్యూనికేషన్ నథింగ్ ఈజ్ వ్యాలిడ్. సో దానికి ఇది ఉండదు కదా, శాంక్టిటీ ఉండదు. సో ఇక్కడ ఈ ఫస్ట్ పాయింట్ ఏంటి? పాయింట్ నెంబర్ 1. సో usually under normal circumstances the what is that the recommendation of the governor is required, but it is not mandatory. So the president can, it is the sole prerogative of the, it is the sole power of the president. So written recommendation is just to enhance the federal spirit in order to get a reasonable opinion from the governor, that's it. But it is not mandatory. The president, if he satisfies, if he feels that the constitutional machinery in the state is not run according to the guidelines given by the constitution, or the center's guidance or directions are violated, then the president can impose with or without the recommendation of the governor. So what if the governor doesn't recommend? The president should not impose? Or what is governor? He is an agent of the center. Though it is a constitutional authority, he is an agent of governor appointed by president under his hand and seal. So it is implied that the governor's recommendation in this regard is, though it is desirable, it is not always necessary. It is not mandatory. So which means the president can impose president's rule with or without the recommendation of the governor. This is, so cannot be imposed, no, this is wrong. Then the second thing is, every proclamation of president's rule must be approved by both the houses of parliament within a stipulated time. Is it correct or not? Every proclamation of president rule, if the president declares in some states, say for example in some state the president has declared president rule, it must be, whether it must be ratified by both the houses or not, it must be accepted by or approved by both the houses, both Lok Sabha and Rajya Sabha within a stipulated time. What is the stipulated time in this particular case? Within 2 months. Within 2 months both houses, both Lok Sabha and Rajya Sabha must approve the proclamation of the president rule, otherwise it lapses. If they approve, then what happens? How long it lasts? It lasts for 6 months. After 6 months, if they want to continue the president's rule, then again it goes for the approval of the parliament. So every 6 months parliament must give the approval. So this is the correct one. Okay. Within a stipulated time, within 2 months both houses must give the assent, otherwise the president rule lapses. Consider the following statements. Okay, statement number 1. The office of governor of a state is considered as an employment under the central government. This is it correct or not? Why not? Constitutional office. Governor, president, governor, etc. These are vice president. All these are constitutional offices. They were mentioned in the constitution itself. They have constitutional sanctity and protection. Constitutional authorities or offices or institutions. So they are not an employment under the central government. They are not an employment, which means employment means any central, for example, I am doing a central government job. So I am an employee under central government, but the governor is not. Though he is appointed by the president, but president is, though president forms part of the executive, he is the executive head of the state, this is not an employment. That is a constitutional post. They have to protect the, they have to uphold the constitution. While doing their oath, the governor and these constitutional bodies, what they do in their oath, what they say, they have the responsibility of upholding the constitution, upholding the constitutional values and its spirit. So that is not an employment. So what is an employment? As an employer, I will follow the constitution. I don't have the obligation of upholding the constitution. Constitutional spirit ni నిలబెట్టాల్సిన బాధ్యత నా మీద లేదు. నా మీద ఏముంది? As an employee, I have the obligation to follow the constitution, whatever is there. So constitutional spirit ని uphold చేసే ఇది నా దగ్గర, నా అంటే we don't have that obligation or responsibility. కానీ ఈ కాన్స్టిట్యూషనల్ అథారిటీగా గవర్నర్కి ఇది ఉంది. ఆ స్టేట్లో కాన్స్టిట్యూషనల్ అథారిటీ, హెడ్ ఆఫ్ ద స్టేట్ కదా, కాన్స్టిట్యూషనల్ అథారిటీగా ఈజ్ ద హెడ్ ఆఫ్ ద స్టేట్. సో అతనికి ఆ రెస్పాన్సిబిలిటీ ఉంది కాబట్టి దిస్ ఈజ్ రాంగ్. ద గవర్నర్ ఈజ్ ఇండైరెక్ట్లీ ఎలక్టెడ్ బై ఏ స్పెషల్లీ కాన్స్టిట్యూటెడ్ ఎలక్టోరల్ కాలేజ్, సేమ్ లైక్ ప్రెసిడెంట్. ఈజ్ ఇట్ కరెక్ట్ ఆర్ నాట్? No. Just now we have discussed that president appoints the governor. So therefore this statement is also wrong. There is no direct or indirect election in relation to the governor. That is one thing. And the second thing is there is no concept of electoral college. For the president election there is an electoral college. For the vice president election, both the houses will participate. Yes. So the next question, consider the following statements regarding the president's address in the parliament. So president addresses on two occasions. What are those two occasions which we have discussed in the class? So after general election, the first session will be addressed by the president, and the second thing, every year, in the first session, which is the budget session. So he addresses nation, and there will be a vote of thanks also at the end of it. So this president address, this very concept of president's address, that means president as the head of the state and head of the executive head, he has to address, he gives his address. He is also part of parliament, right? He is also part of parliament. What are the parts of parliament? Lok Sabha, Rajya Sabha, and parliament means president. All the three constitute the parliament. So he is, since as part of the parliament, he addresses both house of the parliament. So this president address, this very concept traces back to first it traces back to as Act of 1919, which is also called Monte reforms. So under this you can under this act, back then who is the similar authority to the president back then? అప్పుడు president కి similar గా అంటే ఎవరు? గవర్నర్ జనరల్ ఆర్ Viceroy used to address to the Central Legislative Council, Central Legislative Assembly. He used to address the central, this particular precedence, this particular concept of president giving the president addressing the house, both houses, either one house or both houses of the parliament. It began in 1919, and from there on it's been continuing. And in what happened in 1946, we have constituted the Constituent Assembly. So from Constituent Assembly is it's like a de facto parliament. It acted as a de facto parliament up to when we got the constitution came into force from 1950, right? From in this period there is no presidential address. There is no presidential, because there is no president as such, isn't it? So the Viceroy was there, but there is no such address to the Constituent Assembly, because that was specifically constituted for a purpose. What is the purpose? Framing of the Constitution. That's why there is no address. This also acted as Constituent Assembly has served two purposes. One is writing the Constitution, constitution making, and second is serving as the interim parliament, temporary parliament, interim parliament. So though it acted as interim parliament, there is no address of Viceroy to the parliament. And once the Constitution came into force from 1950, who was the first president of India? Rajendra Prasad. He addressed both houses of the parliament after first general election. After first constitution of the assembly itself, parliament itself. So that is the point number 1. It is correct. And point number 2, the president's address is the only occasion in the year when the entire parliament comes together. Is it correct or not? But you don't get the other one every year, right? The other one, when will you get? You will get only once in 5 years. Once in 5 years. Usually you will get it once in 5 years. After every general election means you will get it. So what comes every year? The president address only happens once in a year. All the entire parliament comes to. Since he is also part of parliament, he addresses the parliament only once in a year. Only once in a year. So the entire parliament, see the word, see the entire parliament means that includes president also. There is no address. President will
Statement is president's address is the only occasion where entire parliament comes together. Togetherness of parliament.
For the sake of addressing. For the sake of addressing. Not for other purpose. Little bit confusing. So in relation to this only, presidential address, because they see the entire question is related to the presidential address only, not for other purposes. And the third thing is, in the past there are instances where president's speech is delivered by vice president discharging the functions of the president. It happened on several occasions when the president's seat is either vacant or president is absent from, then whoever is doing the president duty, usually the vice president, and in some cases the CJI, Chief Justice of Supreme Court, also addressed. So that was the case. In cases where the president couldn't deliver his speech, then that was done by the vice president. The vice president, in the capacity of the president, he addressed the houses. Next question. Consider the following statements regarding the public account of India. So we have how many accounts? 3 accounts. One thing is 3 funds. 3 funds. One thing is Consolidated Fund of India. The second is Contingency Fund of India. The third is Public Account of India. So this is under, I think, 266 2. One is 267 I think. Contingency fund is 267. ఒకసారి చెక్ చేయండి. ఇది 266లో 1 అనుకుంటా, ఆర్ వైస్ వర్సా. ఒకసారి చెక్ చేయండి ఆర్టికల్స్. 267 రైట్. 266లో 1 అనేది 266లో 1 కన్సాలిడేటెడ్ ఫండ్ ఆఫ్ ఇండియా, 266లో 2 అనేది పబ్లిక్ అకౌంట్ ఆఫ్ ఇండియా. దీస్ ఆర్ ద 3 funds which we have discussed in the class. And now there are certain statements regarding the public account of India. Statement number 1, public account of India accounts for flows for those transactions where union government acts like a banker. Union government acts like a banker. This is the statement number 1. So in even before that, before even statement 1, we must discuss what is the public account of India. So we have to discuss the what is the public account of India. So what constitute public account of India? Asal public account of India ante andulo em untayi, ఏ funds ఉంటాయి. So అందులో ఏముంటాయి? It includes state provident funds, small savings, deposits. So it includes these particularly the deposits and savings of people, deposits and savings of the people. So one thing is deposits and savings, whether it's small savings or some big savings also will be there, that depends. Smaller bigger is relative. So here certain provident funds, GPF, EPF, etc., various provident funds, PPF, public provident fund, then pension funds, various pension funds, and the small saving deposits, all of them will go into the public account of India. All of the people's money, it is essentially people's money. What is the difference between consolidated fund of India and public account of India? This is collected from people, because this constitute all the money comes from various sources, goes into consolidated fund India. Every expenditure also comes from consolidated fund of India. All the expenditure comes from consolidated fund of India, and all the incomes goes into the consolidated fund of India. But these are not incomes of the government. These are incomes and expenditure. All the income and expenditure of the government constitute this consolidated fund of India, whereas public account of India, this is not the income of the government. These are the savings or deposits, deposits given by the deposits of the people. So this is essentially, this has nothing to do with the parliamentary approval, where the parliamentary approval, the relation is like, see, the people have saved their money. Why we have called as a union government acts as a banker? What is the role of banker? These two things, right? Deposits and savings. Into it what we will do? We all deposit. We will deposit our money, or we will keep it as savings, and we withdraw money as and when we want. మనకి ఎప్పుడు కావాలంటే అప్పుడు మనీ తీసుకుంటాం కదా బ్యాంక్లో. సో ఈ పబ్లిక్ అకౌంట్ కూడా అంతే. అందులో ఉన్న మనీ, పెన్షన్ ఫండ్ కానీ, ప్రావిడెంట్ ఫండ్ కానీ, అదర్ స్మాల్ సేవింగ్ డిపాజిట్స్ కానీ, అవి వీ విల్ సేవ్ ఇన్ టు ద పబ్లిక్ అకౌంట్, అండ్ వీ విల్ విత్డ్రా అవర్ మనీ యాజ్ అండ్ వెన్ వీ వాంట్. ఫర్ ఎగ్జాంపుల్, ఒక ఎంప్లాయీ రిటైర్ అయిపోతే he will withdraw his pensionary, he will draw their pensionary benefits, or provident fund he will withdraw all together, ఒకేసారి తీసేస్తాడు. సో పాయింట్ ఏంటంటే ఇక్కడ పర్టికులర్గా ఇది బ్యాంక్ అంటే ఏంటి? బ్యాంక్ చేసే పని ఏంటి? ఇట్ యాక్సెప్ట్స్ ద డిపాజిట్స్, అండ్ వెన్ ఎవర్ వీ సీక్ ద మనీ ఇట్ గివ్స్ ద మనీ. సో దట్ ఈస్ ద రోల్. సో ఇక్కడ వెన్ ఇట్ కమ్స్ టు పబ్లిక్ అకౌంట్ ఆఫ్ ఇండియా, ద గవర్నమెంట్ యాక్ట్స్ లైక్ ఎ బ్యాంకర్. Government plays the role of a banker. It accepts the deposit and gives away the money whenever they ask. So andukani ee first statement, this particular statement is correct. The second statement is also correct, because public account constitutes all these deposits and savings. So 1 and 2 are both are correct. The third statement, which is also we have discussed, the expenditure from public account of India requires the approval of parliament. Is it correct or not? No, it doesn't require, because that is not the that is not the income or anything of the government. It has nothing to do with it. It can invest, or the money in the public account. The central government can invest this particular amounts that is there in the public account. It can invest in any which way it wants. ఎలా కావాలంటే అలా ఇన్వెస్ట్ చేసుకొని దాని నుంచి వచ్చిన రిటర్న్స్ని కొంత గవర్నమెంట్ తీసుకొని మిగతావి ఎప్పుడు కావాలంటే అప్పుడు వాళ్ళకి పీపుల్కి విత్డ్రా చేసుకునే ఫెసిలిటీ ఉంది. సో దానికి పార్లమెంట్కి సంబంధం లేదు. సో పార్లమెంట్ ఏంటి? ట్యాక్స్ అండ్ నాన్ ట్యాక్స్ రెవెన్యూస్ ఏదైతే ఇలా వచ్చిన ఇన్కమ్ అంతా దేనిలోకి వెళ్తుంది? కన్సల్టేటెడ్ ఫండ్ ఆఫ్ ఇండియాలోకి వెళ్తుంది. దీనిలోంచి విత్డ్రా చేయాలన్నా, నాట్ ఈవెన్ ఎ సింగిల్ పెన్నీ, ఒక 1 రూపీ అయినా డ్రా చేయాలన్నా దీని నుంచి పార్లమెంటరీ అప్రూవల్ కావాలి. కంటింజెన్సీ ఫండ్లోంచి కూడాను ఇందులోంచి అమౌంట్ తీయాలంటే ప్రయర్ అవసరం లేదు. ఎందుకంటే కంటింజెన్సీ ఏంటంటే సమ్ ఎమర్జెన్సీ సిచ్యువేషన్లో ఏమవుతుంది, ముందే అమౌంట్ తీసేసి లాటర్ విల్ గో ఫర్ ద పార్లమెంటరీ అప్రూవల్. దట్ ఈస్ ద హోల్ థింగ్. సో దీనిలోంచి అమౌంట్ ఎంత 500 crores నుంచి ఇప్పుడు 30,000 crores పెంచమని ప్రపోజల్ ఉంది. ప్రజెంట్ 500 crores ఉంది ఏది కంటింజెన్సీ ఫండ్ అంటే ఎమర్జెన్సీ ఫండ్. దాన్ని 30,000 crores పెంచమని ప్రపోజల్ ఉంది. ఎంతవరకు యాక్సెప్ట్ అవ్వలేదు. బట్ గివెన్ అంటే ఇది ఎప్పుడో పెట్టిన ఫిగర్ ఇది, దాన్ని మార్చాల్సిన అవసరం అయితే ఉంది. సో దీస్ ఆర్ ద 3 statements. 1 and 2 are correct, whereas 3rd is wrong. It doesn't require parliamentary approval even prior or after. Okay. Next statement is, consider the following statements regarding departmental related standing committees. Department related standing committees, also called departmental standing committees. So under this there are number of statements given. The first statement is the DRCs are reconstituted every year by both the presiding officers of the parliament, both Lok Sabha presiding officer as well as Rajya Sabha presiding officer, in consultation with the respective parties and government. Is it correct or not? Is it correct or not? Departmental standing committees is one thing is sure, that they are constituted every year, right? This thing you know, all the departmental standing committees will be constituted every year fresh ga constitute చేస్తారు. But with the by whom? Presiding officer. Is it correct or not? It is also correct. Presiding officers of here in this case Lok Sabha speaker and Rajya Sabha's case it is the chairman. And in anything in parliament is a consultation process. So he has to consult with the respective parties. Who are the stakeholders? The consultation means having some deliberations with the stakeholders. Who are the stakeholders? Government and the opposition parties and other respective parties, main opposition and other respective parties. So they must be consulted before constituting, because they are the stakeholders. So the statement 1 is correct. Statement 2, the constitution has made it mandatory for the members to attend the committee meetings since it scrutinizes key legislations. So is it correct or not? Is it correct or not? But one thing important here is it scrutinizes key legislations. It is true, isn't it? What are the role of departmental standing committees? What is the role of the key role is to scrutinize the key legislations, not just key legislations. It almost scrutinizes every legislation. In every legislation all the key aspects of that particular legislation will be discussed thoroughly. Because why the parliamentary standing committees are appointed or constituted? Because parliament doesn't have that much time to deliberate or discuss each and every aspect. That's why on behalf of the parliament the parliamentary standing committees were constituted. So they will scrutinize their main work is to scrutinize all the legislations, the key aspects, and come up with summaries. So that will be aid, and that will become an aid to the parliament. Parliament doesn't have that much time, right? So in the parliament session itself you cannot discuss everything. So that's why the committees are constituted for the purpose of scrutinizing the legislations. That is true. But is it mandatory for those members to attend the meetings? No, which is not mandatory. The attendance to the departmental standing committees every meeting is not mandatory. That doesn't mean they can do whatever they want. That will be irresponsible. The members means the MPs, if they don't, it is not mandatory for them to attend the departmental standing every meeting of the departmental standing committee. But that doesn't mean they can abstain from, they can refrain from. It is not the case. That is their responsibility to attend the meetings as many as possible, but it is not mandatory. So this is wrong. The third point is the committees of Lok Sabha. The committees of Lok Sabha are more in number than Rajya Sabha. Yes, this is true, because for two reasons. Why the what you call, the numbers is more in Lok Sabha than Rajya Sabha, because the general members, number of members itself is in Lok Sabha is greater than Rajya Sabha. This is direct reason, clearly you can establish. The second reason is, this is the people's house, directly elected by the people. On both accounts, the membership from Lok Sabha is obviously more than the Lok Sabha. So 1 and 3. Option B. So next question. Article 19(2), freedom of speech and expression. Under Article 19, freedom of speech and expression. Under this, certain freedoms were given to the citizens or individuals, because even non-citizens, aliens also have certain fundamental rights, even right to speech also. So under this, certain freedoms were given to the each individual. Under this, there are certain situations. So there are, see, Constitution of India imposes certain restrictions, because every right, whatever fundamental right which is given in the Constitution, they are not absolute. The fundamental rights granted by the Constitution are not absolute. Absolute means absolute means completely, thoroughly granted, fully granted. No, not fully granted. So they have to be exercised with reasonable restrictions. So just because you have given fundamental rights doesn't mean you can act arbitrarily or whatever possible manner. So you have to act responsibly, and all these rights have reasonable restrictions. They are not absolute. All of them have reasonable restrictions. So even freedoms under Article 19 also must be exercised with certain restrictions. They have certain restrictions. What are those restrictions? So you can exercise your freedom of speech and expression, but it must be within, it must not hamper the interests of the sovereignty, integrity of the country. Country's sovereignty and your freedom of speech and expression should not be in the way of the interests of the country's sovereignty and integrity. So you should not speak or express that anything that disturbs the integrity or that threatens the sovereignty of the country. So as long as you speak reasonably while following all the guidelines, then you are entitled to have maximum freedom of speech and expression. But they have reasonable restriction that it should not threaten the country's sovereignty and integrity, which is correct. The second thing, for friendly relations with the foreign countries, friendly relation with not only neighbors but all the foreign countries. So you should not disturb the friendly relations with your speeches or actions or expressions should not disturb our country's friendly relations with neighbors or any other foreign nations. This is also a reasonable restriction, right? Reasonable restriction. So the third thing is preventing incitement to commission of an offence. Incitement to an offence, which is also a reasonable restriction. You can speak whatever you feel like, whatever mana mind lo edaina unnado free ga express cheyochu. That doesn't mean you should incite offence, ante communal violence gaani vere vallaki offence gaani incite chesetattu undakudadu. So that is the whole aim of which we have discussed. Certain offendings is defamation, contempt of the court, etc. all these things, all these aspects come under reasonable restrictions. You can exercise the maximum possible or maximum reasonable rights, not absolute rights. So there was a question given prelims lo way back 4 or 5 years back a question ichadu. So what does mean absence of restraints? Absence of restraints ante enti ante freedom liberty ante absence of any sort of restrictions or restraints, obstacles లేకపోవడం. But that means absolute freedom అందరికీ ఉందంటే ఏంటి? What does absolute freedom mean? Which means nobody has any freedom, because అంతే కదా, అందరికీ ఫుల్ అబ్సల్యూట్ 100% ఫ్రీడమ్ ఉందంటే మిగతా వాళ్ళకి రియాలిటీ ఏంటి దాని అర్థం? ఎవ్రీబడి ఈజ్ ఎంటైటిల్డ్ టు డూ వాట్ ఎవర్ దే వాంట్. సో ఐ వాంట్ టు కిల్ సంబడి. సో others rights are violated. Others, which means if everybody has absolute freedoms or liberty, which means nobody is having any liberty in the true sense. So all these. Next question. Consider the following statements. First statement, according to the Constitution of India, the governor shall from time to time summon the house or each house of the legislature. అంటే ఒక హౌస్ ఉంటే ఒక హౌస్ అంతే కదా. ఇక్కడ why he said house? Because in certain states, in 6 or 7 states only, there are what you call the name, and 2 chambers. In only 6 or 7 states there are 2 chambers, whereas in most of the other states there is only one house. So that's why either house ఒకటి ఉంటే ఒక house, each house, if there are 2 houses, each house of the legislature of the state to meet at such time and place as he thinks fit. So can governor do that or not? Can governor do that or not? Yes, he can summon according to Constitution of India under Article 174, I think. Under Article 174, the governor can summon each house or both houses or either house of the legislature to meet at such a time and place he thinks fit. Yes, this option is correct. This statement is correct. The second statement is the governor always has to act on the aid and advice of the cabinet and cannot decide on his own on summoning the house. The governor has always to, when it comes to the summoning, can he do on his own, which means it's a discretionary. Is it his discretionary power, or in this situation or in this occasion also he has to act according to the aid and advice tendered by the cabinet? ఈ సిచ్యువేషన్లో అతను డిస్క్రిప్షన్ ప్రకారం సమ్మన్ చేయొచ్చా ఎప్పుడు కావాలంటే అప్పుడు, లేదంటే ఈ సిచ్యువేషన్లో కూడా అంటే వైల్ సమ్మనింగ్ ఆల్సో హీ షుడ్ అబైడ్ బై దేర్ ఎయిడ్ అండ్ అడ్వైస్. ఏంటి ఆన్సర్? వాట్ డూ యూ థింక్? ఇన్ వాట్ కేసెస్? నార్మల్లీ అంటే ఏంటి? అండర్ నార్మల్ సర్కమ్స్టాన్సెస్ అంటే ఇప్పుడు మనకి కలెక్టివ్ రెస్పాన్సిబిలిటీ అంటాం. పార్లమెంటరీ దీంట్లో ఏంటి ప్రెసిడెంట్ రోల్, వాట్ ఈస్ ద రోల్ ఆఫ్ కౌన్సిల్ ఆఫ్ మినిస్టర్స్? టు ఎయిడ్ అండ్ అడ్వైజ్ ద ప్రెసిడెంట్ అట్ ద సెంట్రల్ లెవెల్, టు ఎయిడ్ అండ్ అడ్వైజ్ ద గవర్నర్ అట్ ద స్టేట్ లెవెల్. అదే కదా, దట్స్ ద రోల్. గవర్నర్కి ఎయిడ్ అండ్ అడ్వైజ్ నార్మల్. ఇక్కడ సెంట్రల్లో ఎలాగా ఆర్టికల్ 163 కింద స్టేట్లో ఉన్న క్యాబినెట్ ఆర్ వాట్ ఎవర్ అంటే కౌన్సిల్ ఆఫ్ మినిస్టర్స్, దే హ్యావ్ టు ఎయిడ్ అండ్ అడ్వైజ్ టు ద గవర్నర్ ఆన్ ఆల్ ద ఎగ్జిక్యూటివ్ మ్యాటర్స్. బట్ అండర్ దీస్ సర్కమ్స్టాన్సెస్ ఇక్కడ సమ్మనింగ్ రిలేటెడ్ దానికి వస్తే, సమ్మనింగ్ రిలేటెడ్ అంటే హౌస్ మీటింగ్ కానీ సమ్మనింగ్ చేయాల్సి వస్తే, వెదర్ ఈజ్ ఇట్ డిస్క్రిషనరీ పవర్ ఆర్ ఇట్ ఈజ్ ఆల్సో decided by the cabinet or council of ministers. So he can under ordinary circumstances he has to abide by he has to seek the aid and advice, but under certain circumstances this is not mandatory. The aid and advice tendered by the cabinet is not mandatory. Usually he has to follow, but in certain cases this is not mandatory, which means in certain instances he exercises his discretionary powers. Governor exercises his discretionary powers. This is one such, particularly the summoning related to proving of the confidence of the government in the house, in the floor, on the floor of the house. If the CM, if the chief minister and his council of ministers, if they have to prove their majority, if they have to prove their confidence in the house, on the floor of the house, then he can summon, because otherwise what if they are not willing to come forward? What if the cabinet or council of ministers not willing to come forward, or they are not abide by the summon of the governor? Then there will be no dissolution or whatever. President, say for example, there is no point of change, there is no provision for changing the government, right? For example, if it is evident that ఒక అంటే పార్టీలో పవర్లో ఉన్న వాళ్ళకి మెజారిటీ లేదు అని తెలిసి, దే కెనాట్ ప్రూవ్ దేర్ కాన్ఫిడెన్స్ ఆఫ్ ద హౌస్. సో అప్పుడు ఏం చేస్తారు, వాళ్ళు రారు, దే మే డినై. అండర్ దోస్ సర్కమ్స్టెన్సెస్ ద గవర్నర్ హ్యాస్ టు ఎక్సర్సైజ్ హిస్ discretionary powers, so he can summon. So this is not always true. So this is the only statement which is true. So option A is correct. So next question, consider the following statements regarding Indian Citizenship Act 1955. Indian Citizenship Act 1955, according to which there are certain statements given. So first statement is, according to the act, any Indian citizen who acquires foreign citizenship ceases to be an Indian citizen. Is it correct or not? Yes, it is correct. Under Citizenship Act 1955, there is a section called 9, section 9 of Citizenship Act, Indian Citizenship Act, which states that, if any Indian citizen who acquires voluntarily acquires the citizenship of another state or another country, foreign citizenship which is called, then he ceases to be an Indian citizen. There is a direct provision in section 9 under Citizenship Act. So this is statement 1 is correct. Statement 2, the act specifies, the act which means 1955, Citizenship Act of 1955, the act specifies the procedure required for termination of Indian citizenship in case of acquisition of foreign citizenship. So does it mention any procedure? No, it does not mention any procedure. It simply states the first statement. What it says, if any Indian citizen voluntarily acquires the foreign citizenship, he ceases to be an Indian citizen from that date, from there on. Akkadi nunchi he ceases to be an Indian citizen. There is no other procedure which is mentioned in the 1955 Act. There is no other procedure, termination procedure. There is no exhaustive terminative procedure. There is no termination procedure. There is no such procedure. Simply the statement is given that from there, which means from there on means from that date on which he acquires the foreign citizenship, he ceases to be an Indian citizen. So there is no further procedure involved. So statement 1 is correct, statement 2 is wrong, and statement 3, some of the provisions of the law, which law? 1955 Act 1955, Indian Citizenship Act 1955, some of the provisions of the Indian Citizenship Act 1955 does not apply when India is at war with any country. Yes, it is correct. It is also exclusively mentioned in the Act 1955 that when the India is at war, certain provisions related to acquisition of the foreign ship or termination or whatever, these things will not be entertained. It is in the larger interest of the country's sovereignty and security. Country's security, keeping the security in the mind. At that time, all these provisions, some provisions of the Indian Citizenship Act ceases to exist for a certain period. As long as the country is at war, certain provisions will be suspended, because in the interest of the security of the country. 1 and 3 correct. So 1 and 3, the Act specifies the procedure. No, the Act does not, Citizenship Act 1955 does not explicitly mention any procedure for the termination. So it simply says the first statement, if any Indian citizen voluntarily acquires the citizenship of some foreign state, then from that date he ceases to be an Indian citizen. That is the only thing. There is no other procedure involved. Simple. They made it simple. Enti meeke doubt enti? There is no further procedure or process involved in it. From if some for example M.F. Hussain, he left the country because of some religious sanction issued by the Hindu organizations. He had some threat. He felt some threat and he left the country and he acquired the citizenship of Qatar. Then the Indian citizenship automatically ceases to exist. His Indian citizenship, from that date he ceases to be an Indian citizen. Got it right? Okay. So 1 and 3. Consider the following statements regarding the sessions of Parliament in India. So parliamentary sessions will be there, right? How many sessions must be conducted in an year? At least 2. So there should not be gap of 6 months between 2 sessions. So at least 2. But in reality, how many sessions we have been conducting? 3 sessions. Okay. So first statement with regard to the sessions of Parliament. First statement is India does have a fixed parliamentary calendar. Do you have a fixed parliamentary calendar? We have fixed sessions. What are those? Budgetary session and then monsoon session and winter session. We have fixed sessions but not fixed calendar. Sessions are fixed means we have 3 sessions. We conduct 3 sessions for sure, but the calendar is not fixed. So that will be based on, if it is fixed means which is so rigid. If we fix the calendar also, it will be rigid, but we made it flexible. So the calendar is not fixed. So it is not fixed. The summoning of Parliament is based on the provisions of the Government of India Act 1935. Is it correct or not? The summoning of Parliament is based on the provisions of the Government of India Act. Is it correct or not? We have borrowed parliamentary proceedings from majority of the parliamentary proceedings, the ground level governance or parliamentary setup from 1935 Act. Well, most half of the provisions, half of the constitution is heavily borrowed from 1935 Act. So these parliamentary sessions related aspects and the summoning related aspects, most of the things were borrowed from 1935 Act, which means the point number 2 is correct. And number 3, statement number 3, by convention Parliament meets for 3 sessions in a year. Is correct or not? By convention, because it is not mentioned anywhere. It is not mentioned in the constitution. What is mentioned in the constitution? The Parliament, there should not be a lapse of more than 6 months between 2 sessions. That was only mentioned in the constitution, but we have actually in reality we have been conducting 3 sessions, which means by convention. By a convention means long since we have been following this convention. So by convention the Parliament meets for 3 sessions, which you have mentioned just now. So 2 and 3 are correct. Option C. Okay, with this test 6, the discussion session for the test 6 is over.